Sorry. Good morning. The January 31st, 2023 meeting of the Charlotte Zoning Board of Adjustment is now in session. I am Deborah Dryden, co-chair. Also sitting on today's board is Amy Sun, Marsha Williamson, Tariq Hamid, and Hamilton Court. Also present are Lisa McCarter, our planning project manager, Tari Hagler-Gray, Senior Assistant City Attorney, Jill Sanchez-Myers, Senior Assistant City Attorney, Terry Edwards, Clerk to the Board, and Candy Thomas, Veritex Court Reporter. I'd like to start by acknowledging that we are conducting this meeting in person. This is the first in-person meeting in 2023 of the Charlotte Zoning Board of Adjustment, and I would like to ask for your patience today as we proceed. There may be slight delays as we transition between speakers, participants, and presentations. The Zoning Board of Adjustment is a quasi-judicial body that is governed by the North Carolina General Statutes and the Charlotte Zoning Ordinance. We conduct evidentiary hearings on requests for variance and appeals, among other requests. Before we begin to hear the cases on today's agenda, I would like to provide some important information on the steps that were taken to ensure that each party's due process rights are protected as we proceed. Notice of this meeting was provided to the applicants and the public in several ways. Notice of today's hearing was mailed to property owners within 300 feet of each subject property and notified the property owners of the in-person meeting. Notification letters also stated to contact the city immediately if there were any objections to the cases being heard on today's agenda. Notice was also provided by placing signs on each property and by publishing notice on the city's website. The notice for today's meeting contained information about means by which the public can access today's proceedings. Finally, any individual wishing to participate in today's evidentiary hearings were required to sign up prior to today's proceedings. This information was also included on the board's website. The hearings, applications for a variance from the regulations in the zoning ordinance. Applications for the variance from the regulations in the zoning ordinance and the recommended agenda will be as follows. The zoning administrator or a zoning staff member will identify the case and recommend approval of the variance with any recommended conditions based on specific reasons. The chairperson will ask if anyone wants to speak in opposition. If there is such a person, then the case will be moved to the regular agenda and will be heard at a later date. The chairperson will ask if the board has questions for staff or if there is any reason the board wishes to move the case to the regular agenda. The chairperson calls for a motion and a second to approve the variance. The chairperson will hold a roll call vote. In order of the agenda, the order of the agenda is as follows. All parties who plan to give testimony, pro or con, must be sworn in. A zoning staff member will explain why a permit was denied or why a variance is requested. The board may question the staff member and then the applicant may question the staff member. The applicant presents their testimony for the case. The board may question the applicant and the staff member may question the applicant. The applicant may present sworn witnesses. They will be subject to questioning. Other parties wishing to speak, pro or con, will be given reasonable time to present sworn testimony. The staff and then the applicant will be given an opportunity for rebuttal. The chairperson calls for a motion and a second to approve the variance. The chairperson will hold a roll call vote. After hearing each case, the board will review each case and render a decision. This is usually done in closed deliberations after hearing each regular agenda case. However, the board may elect to take up to 30 days to render a decision. You may remain present during the deliberations, or you may call the zoning staff after the session to receive the decisions of the board. All exhibits must remain with the board Exhibits were recommended to be provided to the clerk no later than 12 p.m. on Monday, January 30th. If your case is not appealed to Superior Court after 30 days, you may pick them up or they will be destroyed. If you feel there is a conflict of interest of any member of the board or an association that would prejudice your case, please let it be known at the start of your case. The board is acting in a quasi-judicial capacity for purposes of this hearing and can only accept sworn testimony. While the board will not specifically exclude hearsay evidence, it is only given limited weight. The North Carolina State Bar has issued an advisory opinion that is the unauthorized practice of law for an individual who is not an active member of the bar to appear for another or otherwise assist or represent another at quasi-judicial hearings on zoning and land use matters. All applicants should have been provided with a copy of that advisory opinion as part of the application packet. If you are a property owner or a non-lawyer here on behalf of a property owner and have not received a copy of that opinion, please notify the clerk. The documents will be provided to you. If, as a result of this advisory opinion, the applicant would like to request a continuance of his or her case, the board will consider such request at the start of the case. Appeal from this board to the Mecklenburg County Superior Court, you have 30 days from the date of the board's written decision in which to appeal in accordance with NCGS 160D-405D. In order to receive a written copy of the decision, any aggrieved party must file a written request for a copy of the board's decision by filling out the form, which must be filed with the board's clerk of court or chairperson at the time of the hearing of the case. We will hear 7 cases today, 1 recommended item, 5 regular agenda items, and 1 appeal. The first case, number 2022-051, 13227 Woody Point Road, is requesting a continuance. Do we have to vote on that? Okay, all right. So, board, we need to vote on that request for.
Chair,
Yes, I'm sorry.
oh, they're requesting a 2-month continuance?
A 2-month continuance. All right, thank you. So the case number 2022-051 is requesting a 2-month continuance, and the board will vote on that now. All right. Ms. Sun?
We need to move to,
Yeah, okay, you make a motion, Ms. Sun,
Yes, to approve.
the continuance. Okay, so a motion's been made to approve the continuance. Do I have a second?
second,
Okay, now we'll have a roll call vote. Ms. Sun?
Approve.
Mr. Williamson? Approve. Mr. Hamid?
Hamid, approve.
Mr. Court?
court approve.
Dryden, approve. So that 2-month continuance is approved. Thank you. Do I do the other continuance now? Okay. All right. Another continuance request is case number 2023-006. They are requesting a continuance from this board. Do I hear a motion?
Motion to approve a continuance.
Second?
Second,
Okay, the motion has been made and seconded. Roll call vote. Ms. Sun?
Sun approve, second.
Okay. Mr. Marshall?
Approve.
Mr. Hamid?
Hamid, approve.
Mr. Court?
court approve.
Dryden approved. So case 2023-006 is continued for 1 month. All right. As we go through these recommended and agenda items, the clerk to the board will read the names of anyone who opposes the case. All right. All right, we're moving into our agenda items. Case number 2023-001. And I need to swear in Ms. McCarter. Do you swear and affirm to tell the truth, the whole truth, and nothing but the truth in the matter at hand? All right. So this is the PowerPoint presentation. Thank you.
Our first case is a residential rear yard variance request. The applicant is requesting a 10-foot variance from the required 45-foot rear yard to permit an addition on the back of a non-conforming home that's within the required rear yard. So I'll give you a minute to look over your findings.
All right, thank you. Ms. McCarter, you may continue.
Exhibit 1 is a vicinity map of the property. Exhibit 2 is a zoning map. The property is zoned R3, single family. Exhibit number 3 is an aerial map of the property. Exhibit 4 is a close-up aerial map of the property. The property is a corner lot, and the front setback is located on Twyford Place. The street side yard is along Hempstead Place. Exhibit number 5 is background. The property was subdivided in 1949, and the home on the property was built in 1959. Exhibit number 6 is the variance request. There is a 45-foot required rear yard shown in red. The established 14.6-foot rear yard is shown in blue. Since the existing home shown in yellow predates the current ordinance requirements, it's legal nonconforming. The applicant would like to add an addition to the rear of the home, shown in purple. The addition would not be permitted since it is an expansion of a nonconforming structure in the required rear yard. The applicants are asking for a 10-foot variance from the 45-foot required rear yard to allow the addition. So the yellow is the existing home, and it's located in the rear yard, and then the purple is the proposed addition. Exhibit 7 is considerations. The hardship was not caused by the applicant since the home is non-conforming and has an established rear yard of 14.6 feet. The hardship is caused by conditions peculiar to the property. The established setback is 44 feet, so that's on Twyford, and that's 14 feet greater than the required 30-foot setback. Since the home is set back further on the lot, there's less building area to the rear of the home. The requested rear yard of 35 feet is less than the existing encroachment. Exhibit number 8 is considerations. There are mature trees along Twyford Place that would make it difficult to expand to the side of the home. So this is the view from Twyford, and you can see this is Hempstead looking towards Twyford. Granting the variance will not alter the essential character of the neighborhood and will not be easy to detect since it will be screened from view. The applicant states the variance will allow an addition to align with the existing rear of the home. Exhibit number 9 is a photo of the property. And that's the end of my presentation if you have any questions for me.
Does the board have any questions for staff? Is the applicant here, Mr. Edwards?
Yes, ma'am.
Applicant, all right, would you, if you'd like to come forward?
They can't speak since it's recommendation.
It's what?
It's recommendation, so.
So
they
we don't
can't
have to
speak.
do that?
Yeah.
Oh, okay. I beg your pardon, I'm just reading along here. All right, so no questions for staff? All right,
Just want to make sure there's no one here in opposition.
okay, is there anybody in opposition?
No, ma'am.
Okay. Thank you. All right, if there is no one in opposition and it is a recommended agenda item, we will go into our deliberations. We have concluded the portion of this case that pertains to the presentation of evidence. So, board, do you have do I have a motion to accept this recommendation?
I make a motion to approve.
Do I have a second?
Sun second.
Oh, okay.
Sun, second.
All right, if we have a motion and a second to accept this recommendation, we'll do a roll call vote. Mr. Court,
Yes.
Mr. Hamid,
Hamid, yes.
Mr. Williamson,
Williamson, yes.
Ms. Sun,
Sun, yes.
Dryden, yes. So now we will look at the finding of facts. I don't see any reason to make any changes since we have approved this. Do I have a motion to approve the finding of facts?
Hamid, motion to approve the findings of facts.
Do I have a second?
Court, second.
All right, Ms. Sun,
Sun, yes.
Mr. Williamson,
Williamson, yes.
Mr. Hamid,
Hamid, yes.
Mr. Court,
Court, yes.
Dryden, yes. So the finding of facts are approved. Thank you. Okay. All right, we will now move into our agenda items. This is case number 2023-002.
Staff supports this requested variance. We've placed it on the regular agenda in case there are any questions. So this is a commercial temporary access variance request. You want to swear the applicants in now, or?
Yes, we can swear in the applicants now. All right, if you'll, anyone who wants to speak, please. Please state your name and as you swear in. Do you swear and affirm to tell the truth, the whole truth, and nothing but the truth in the matter at hand? And your name? Say it again. Paul Brett. Thank you.
All right, I'll give you a few minutes to look over your finding.
Thank you, Ms. McCarter. You may continue.
Exhibit number 1 is a vicinity map of the property. Exhibit number 2 is a zoning map. The property is zoned Transit-Oriented Development Neighborhood Center, so we call that TOD typically. Exhibit number 3 is an aerial map of the property. Exhibit 4 is a close-up aerial map of the property. Exhibit number 5 is the variance request. The property has frontage on South Tryon Street, and that's a major arterial maintained by NCDOT. It also has frontage on East Peterson Drive, and that's a local road maintained by CDOT, or the Charlotte Department of Transportation. The applicant intends to construct a multifamily development with a parking deck that will provide a portion of the required parking for the Old Mecklenburg Brewery at 4150 Yancey Road. So that's directly below the property. There's an easement agreement between the subject property, Old Mecklenburg Brewery, and the property at 4210 Yancey Road. So that's the property over here. And this is to use an anticipated shared access drive on Yancey Road. During construction on the subject property, the Yancey Road access will be closed or only open to construction traffic. The applicant wishes to provide a temporary parking lot for non-construction traffic for safety reasons, and also so that OMB can remain compliant with their parking requirements during construction, because we'll see in a later slide that right now OMB is using a portion of this property for their parking. The code does not permit access to off-street parking from frontages located across from single-family residential districts and TOD. Since Yancey Road will be closed only for construction traffic, the applicant wishes to locate the access on South Tryon. South Tryon Street is located across from non-residential zoning, but NCDOT denied the request and required the access to be located on East Peterson. East Peterson is located across from UR2 and R4 single-family residential zoning districts, and access is prohibited by code. The applicant is requesting a variance to permit the temporary access to the parking lot on East Peterson Drive. So right in this red area here. Exhibit number 6 is considerations. Staff supports the requested variance with the condition that a zoning hold be placed on the property to require removal of the temporary access to off-street parking prior to the release of the certificate of occupancy. The applicant has agreed to the proposed condition. The hardship was not a result of actions taken by the applicant because the applicant has exhausted the option of locating the access from South Tryon. The hardship results from conditions peculiar to the property. Although South Tryon frontage is located across from a non-residential zoning, temporary access was denied by NCDOT. The temporary access cannot be located on Yancey since it will be closed temporarily or used only for construction traffic during construction. Exhibit number 7 is considerations. The requested variance is consistent with the spirit and intent of the ordinance. You can see in the aerial on the left that a portion of OMB's existing parking is located on subject property. The temporary access and parking will allow OMB to remain compliant with their parking requirements during construction. It will also allow construction traffic and non-construction traffic to be separated for safety reasons. NCDOT has stated that the daily traffic on South Tryon Street is too high for the temporary access. CDOT supports the requested variance. Hardships result since temporary access along South Tryon is prohibited. The Yancey Road access will serve construction traffic, and access from East Peterson is prohibited by code. And exhibit number 8 is a photo, and this is East Peterson in the actual location that the access would be right next to the construction trailer. And that's the end of my presentation, if you have any questions for me.
The board, do you have any questions for staff?
Okay, so this is the multifamily property that is asking for the variance, okay? And there are no permanent entrances. Are there any permanent entrances off of South Tryon Street?
Not to my knowledge. That
Okay. Do they own the entire parcel over to Yancey, or not East Yancey, but the Peterson?
yes, so they own, it kind of is jagged
Okay.
here. They don't own this property, but they own all the other.
And this is a temporary access, meaning in the future that they'll just close that off. So eventually the only access to the proposed multifamily is going to be across an easement from Yancey Road?
And I'll let the applicant address that, yeah.
So this is just a temporary construction entrance. You just can't have it in front of families and.
So the blue area is where the parking's going to be for the OMB? Where's the permanent parking going to be?
So that's why we're here today, asking for the temporary variance.
Do we know the intent of the, the prohibition of the entrance, or?
It's to not have a lot of traffic in front of residential properties.
And we have a full presentation. Lisa did a great overview. We have the team from Land Design as well as the developer if you have questions. But again, I think Lisa covered the facts to our satisfaction. This did go through a major rezoning. So all of the neighboring property owners were aware of there was no opposition to the rezoning for this master development.
I assume you're planning to screen the temporary parking lot during construction from the neighbors?
I'll defer to the Land Design team.
Gray, that's representative of temporary buildings that will be screening, as well as some screen shrubs.
What's a long-term plan for that gravel lot? That's phase 2 of the development. What does that look like in the interim? I know this is kind of aside from the case facts, but I'm just kind of curious.
Till
Thank you.
Any other questions from the board?
If I'm correct, the temporary parking lot really takes the construction traffic and puts it over on Yancey. So it doesn't have all that construction mess going out towards the residential. Is that right?
Correct. It's intended to bifurcate the traffic entirely for safety considerations. So the public should be accessing Peterson to park in the temporary parking. The only exception to that, cap spaces for OMB here, they'll be access here. Closed off past the loading dock is my understanding. So OMB will access their loading. Access is not going to be available. Entirely closed at certain phases during the construction, or that will be construction only. Correct me if I've misstated any of that.
So we're approving this temporary access, not the permanent access. And temporary access is not usually allowed.
Correct.
right?
There's no delineation between temporary and permanent, so any access wouldn't be permitted.
Okay.
We've just agreed. And again, the parking lot can be there. It's the access point that is the issue. No access point is allowed. We're proposing, so that everybody can be comfortable, this would go away when they have the CO for the deck.
Yes, it is. We've agreed to the condition as,
Yeah.
no, no.
I think that's in our application. But
And you'll find it in your findings too.
Okay, so the ordinance is not against temporary accesses. The ordinance is against an access across from residential or a parking lot. Okay.
Any other questions? Is there anybody speaking in opposition?
No, Chair.
If you have no more questions for staff and no more questions for the applicant, any questions for the applicant, or the applicant wants to do a
The
presentation?
applicant wants to do a presentation.
I think we're fine deferring to Ms. McCarter's presentation without repeating all of the facts, basically.
Thank you. All right, staff, board, any more questions? All right, if not, this concludes the presentation of evidence. The board will now begin its deliberations. Interested parties are not permitted to address the board during this portion of today's meeting. However, everyone is permitted to remain present and listen quietly to the board's decision and votes. We have now concluded the portion of the case that pertains to the presentation of evidence. The board shall now proceed to the discussion and decision portion of the cases. Interested, oh, I just read that. In order to receive a written copy of the decision, any aggrieved party must file a written request for a copy of the board's decision with the board's clerk of chairperson or at the end of this hearing. All right, deliberations. Mr. Williamson, comments?
I think it makes sense. There's a lot of construction over there, so I don't think it's going to be any burden on the neighbors. So they are.
Okay, Mr. Hamid?
I lean to approve this for a couple of reasons. Obviously, it's a stopgap measure for development. We don't want to stifle development in the city. I lean to approve this for a couple of reasons. Primarily, this seems like a stopgap measure to encourage development in the city, especially in this area. The applicant obviously has done their due diligence. There's no opposition, so I see no reason not to approve it.
Okay, Mr. Hamid?
Court.
Court, I'm
Yeah,
sorry.
that's okay.
Mr. Court, I beg.
All the H's. No, I appreciate you pulling this to the regular agenda, explain it, and everybody's time explaining it, because it was a little complicated in the information. I thought I understood it, and it was even more complicated, but yeah, I'm leaning, it makes a lot of sense to me, and I think it's approvable for sure.
Ms. Sun?
Sun approve because the temporary access is necessary for the construction of the multifamily.
And I also, I'm leaning toward approving this. It's nice that you did the explanation, because when I looked at all this, I thought, what are they talking about? So, but I can see why the temporary access, and as long as there's nobody in opposition, so all the neighbors have approved this, so. Any other comments from the board? Okay, do I hear a motion?
Hamid, motion to approve.
Okay, do I hear a second?
Court, second.
Can I ask for just clarification for the record? Is that with the condition that was proposed?
Hamid,
Okay.
motion to approve with the condition that's proposed.
Court, second.
Okay. All right, we will now vote. Ms. Sun,
Sun, yes.
Mr. Williamson, Mr. Hamid,
Hamid, yes.
Mr. Court,
Court, yes.
Dryden, yes, we approve with conditions this request. Thank you.
Findings of fact?
Yes. All right, now we need to look at the finding of facts. I don't see any change since we have approved this variance. Do I hear a motion to approve the finding of facts?
Court move to approve.
Do I hear a second?
Williamson, second.
Okay, Ms. Sun,
Sun, yes.
Mr. Williamson,
Yes.
Mr. Hamid,
Hamid, yes.
Mr. Court,
Court, yes.
Dryden, yes. The finding of facts, the conditions of law are approved. Thank you all very much. Have a great day. Okay. All right, we're moving on to another agenda item, case number 2023-003.
All right, this is an accessory structure variance. The applicant is requesting a variance to permit a pool within the established setback and 7.3 feet into the 360-foot required setback. The applicant's here and has also prepared a presentation.
Let's swear in the applicants. Do you swear and affirm to tell the truth, the whole truth, and nothing but the truth? Matter at hand.
I do.
I do.
Do they state their name now or when they start to talk?
Todd Ware, 9904 Flower Bonnet Avenue. I'm with Johnson, Allison and Horde, and I'm here on behalf of the applicant and the owner.
Eric Ridenhour. I'm the owner of the property. I live at 6205 Carnegie Boulevard, apartment 201, Charlotte, North Carolina.
Thank you. All right, thank you. You may continue.
Would you like a minute to look over your?
Yeah, let's look at our finding at the recommendations. Okay, thank you.
Exhibit number 1 is a vicinity map of the property. Exhibit number 2 is a zoning map. The property is zone R3, single family. Exhibit number 3 is an aerial map. So you can't really see that outline, but it goes down. Exhibit number 4 is a close-up aerial map of the property. Exhibit number 5 is background. The property was subdivided in 2020, and the home on the property is nearly completed. The property meets its frontage requirement along Gilchrist Road. So this is Gilchrist Road down here. The front of the home is oriented towards the lot's rear yard and private drive Lewis Patrick Lane. So this is where the front of the home is facing. And it provides access to Montclair Avenue. Exhibit number 6 is the variance request. There's a 360-foot setback off Gilchrist Road shown on the recorded plat that supersedes the required R3 setback. The established setback is located between the right-of-way of Gilchrist and the existing home. So we've got the required setback and the established setback. There's about a 2-foot distance between the established and required setback. The property is currently compliant with the established and required setback. Per code, accessory structures are not permitted in the established or required setback. The applicant's requesting a variance to locate a pool within the established setback and 7.3 feet into the required 360-foot setback. So the yellow is the variance requested area. Exhibit number 7 is considerations. Staff finds the variance request does not meet all the criteria for granting a variance. The hardship results from actions taken by the applicant since there is compliant area to construct a pool in the established side yard, which is located behind the established setback to the side of the home. So that's in this yellow area. A variance is needed due to the desired size and placement of the proposed pool. If the proposed pool were located in the yellow highlighted area, no variance would be needed. That's this yellow highlighted area. Exhibit number 8 is considerations. The hardship does not result from conditions peculiar to the property. There are some unique features of the property, but there's still compliant area for a pool. The requested variance is not consistent with the spirit and intent of the zoning ordinance. The variance is necessary to increase the size of the pool and the distance from the home. So last year in 2022, the ZBA did grant a variance for an 8-foot encroachment into the required and established setback for the neighboring property at 6226 Lewis Patrick Lane, but that request differed from the subject request. To the left, you can see the previous request had a pool depth of 8 feet, and the pool was placed directly adjacent to the back of the home. The home was built so that it was very close to the required setback, and there was not compliant area in the established side yard to construct a pool. So to the right is the subject request. The subject request is for a pool located between 8 and 10 feet from the home and 14.5 feet in depth. There is compliant area in the established side yard to construct a pool. The rear home elevation submitted with the building permit for the home on the subject property shows the pool directly adjacent to the home. There are some doors on the back of the home, and that, they're right here where it kind of indents a little bit. There's about 16 feet of compliant building depth from the doors to the established setback line in the compliant building area. There's adequate depth in the compliant building area to provide spacing from doors by relocating the pool and decreasing the depth. Exhibit number 9 is a photo of the property, and that's the end of my presentation if you have any questions.
Any questions from board or staff?
Lisa, a quick question about pool construction. Are pools, is there any specific zoning restrictions for pools? Like if they satisfy all the setback requirements, it's automatically permissible to have
Yeah.
a pool?
Lisa, can you go back a slide, please? So, all right, I understand where the compliant part is. So what are they, how is that different from what they're proposing? They want to put it farther from the house?
Yeah, so this is what they're requesting. And it encroaches into the established and required setback.
So the picture.
That would be my assumption because on the larger plan, it said pool must be permitted separately.
Any other questions for staff?
So the neighbor's property that this board gave a variance, approved a variance request for is quite different because there was no opportunity, there was no compliant pool area within that established setback or the required setback. And I think just for the purposes of this case, it's unique to point out that fact. And I think what Ms. McCarter is saying is within that compliant area, you could have a pool, but it would have to be significantly smaller than what's proposed and potentially smaller than the neighbors. There's no dimensions on the neighbor's pool, but
It was 8
Oh.
and 22.
so. I mean, I think the difference between the, sorry, this is more deliberation. I'll save my comments for deliberation.
May I speak?
Well,
Yeah.
and rather than asking Lisa questions, we'll just
Cindy.
address the differences in the
All
presentation.
right, staff, do you have any other questions for
No,
Lisa?
you-
Board, do you have any questions for staff?
So I just, so I guess, the front setback and the rear setback, are they kind of flip-flopped here with the frontage being on a separate road on a pork chop lot, or is that? Okay, all right, so. So the previous, so really the front door has a backyard setback.
Yes, sir.
And the backyard has a front yard setback. And this was reviewed previously in the same subdivision, and a variance was granted of 8 feet
Yes.
into the front setback. Okay. All right.
Okay. All right. All right, if you'd like to make your presentation, thank you very much. Please state your name and begin.
Thank you. Good morning. My name is Todd Ware, and I'm with Johnson, Allison, and Horde here in town, and I'm here on behalf of the applicant. The applicant is Copper Builders. They are building the home for Mr. Ridenour. Mr. Ridenour's here, and he's going to speak as well. As mentioned in Lisa's presentation, the home is nearing completion of construction. Eric, that's probably 90 to 95% complete. Before I run through our presentation, which I'll try to figure out the clicker the best I can, I have a couple of supplemental submittals that I would like to add to what we provided staff yesterday. This first one, and I think I have 7 copies of it. It will also be relevant to the next case on the agenda. That is an affidavit from Anthony and Sylvan Pools. They are a major pool installer in Charlotte, one of the largest pool installers in the Southeast. Their general manager affirms in that affidavit best practices when it comes to siting a pool on lots, really on any lot, but will speak to consider very important safety and other structural type issues that are relevant to this question of utilization of compliant building area. As we understand this city's position is you do not meet the variance criteria unless you have utilized every square inch to avoid needing to make the request, but that does not take into consideration the serious issues that are raised and addressed in Mr. Exon's affidavit. The second, and I apologize for this, I do not have 7 copies, but it is a picture from Gilchrist Road, which Lisa mentioned is the public street that abuts the property. It's at the end of the flag lot, which we'll get to. But that is a picture looking to the lot from Gilchrist Road, and you will see the screening, the vegetation. There is no actual access from Gilchrist Road, physical access to the lot, and that's a good depiction of that.
And just for the record, the affidavit is being marked as Exhibit 1, and the picture, the photograph, is being marked as Exhibit 2.
And I also have in the form of a proposed decision letter, meeting the template that has been used by the board in the past, findings of fact and legal conclusions there.
That will be marked as Exhibit 3 for the record.
Got it. Okay, I will try to limit repeating, but inevitably I'll repeat some facts, but please stop me if you want me to move forward. But as Lisa pointed out, here's the lot, and it fronts, physically fronts on, this is Lewis Patrick Lane. It's a private road. The lot configuration was approved at subdivision several years before the applicant or Mr. Ridenour were involved in the property in any way. And you'll see the flag that takes it out to Gilchrist. And the only reason we are here is that is how the lot was approved. And it creates exactly what Mr. Hamid indicated, or excuse me, Mr. Court indicated. The physical front of the house faces the rear yard requirements. The physical rear of the house and lot face the front setback requirements. And here's Gilchrist Road. That front setback requirement is 360 feet from Gilchrist Road. And it, as Lisa's slide showed, it puts it much closer to the home than your standard rear yard setbacks. So if it were not for this odd configuration, which the applicant and Mr. Ridenour were not involved in, we would not be here seeking the variance. Here's the overhead aerial that more clearly shows this is Lewis Patrick Lane. This is Gilchrist. This will show you, and we'll speak to this, the vegetation and the cover. There's a creek running through here. There's a sewer line running through here with a 20-foot easement, and that is relevant to the ability to locate anything in the rear yard of these 4 lots. And it is relevant. This is 6226. This is the next door lot that Lisa showed, for which the board has granted a variance up to 8 feet into the required setback in order to allow a swimming pool. This shows the front of Mr. Ridenour's future home. These pavers, that is Lewis Patrick Lane. This is the front of the home, yet it sets the rear setback, legal rear setback requirements. This picture will show you the backyard, the area in which the pool would be installed and any other accessories. This from the house will show you, whereas Exhibit 2 or B shows you from Gilchrist Road during the springtime and the summer, this will show you during late fall and winter that you still have this screening and coverage here. The creek, as mentioned, runs through here. The sewer line runs through here. There is a detention pond that you see from one of the aerials that is there as well. And just pictures of the back. This aerial will show you, this is 6222. Again, you see the coverage, the detention pond, creek, sewer line running through here. And this is the adjacent home for which the board granted a similar variance request. This just shows, this was submitted with our application, which shows the request. This box, Lisa did a much better job of making it legible to show what was being requested. And the request is for a 14.5. Lisa mentioned depth. Depth of the pool is relevant, as you will see in the affidavit from Mr. Exum. Lisa was using depth to indicate distance away from the home, not depth going down for the pool. This is a closer look of what is requested, and it does 7 feet 9 inches in one area, 5 feet, of course, given the angle of the setback lines, the encroachment into the setback varies as you traverse the lot. The other important fact here is this yellow is the sewer easement. And that is a 20-foot sewer easement, the center line of which is the sewer line. Mr. Ridenour has received the necessary encroachment agreement from Charlotte Water to be able to encroach into the sanitary sewer easement in order to install accessory structures. Now, that issue is separate and distinct from the impact of the setback and the request for the variance. But per Charlotte Water rules, you can only encroach up to 5 feet from the actual sewer line. And Mr. Ridenour's proposal, it will be further than 5 feet from the sewer line. But if you go back to 6220 and the variance that was requested, as Lisa mentioned, this board agreed that, yes, Ms. Talbom is the owner of that lot, and she has provided an affidavit that is in our materials And the board did agree to allow an 8-foot variance into the required setback, putting the pool that was installed 5 feet from the sewer line. The reason that variance request was 8 feet is because the location of the sewer line, independent from the setback lines and independent from the variance request, you could not go any closer to the sewer line for obvious common sense reasons. And so by affidavit in our materials, Ms. Talbom confirms that the only reason she requested an 8-foot variance was that's the only place she could locate the pool because you can't get any closer to a sewer line. Mr. Ridnour will be no closer than 5 feet from that sewer line as well, based on what we have proposed here. This will show you, here is effectively the sewer line. And so he will stay in compliance with his approved encroachment from Charlotte Water. This shows you the required setback line of 360 feet and what, as proposed, the pool would look like. As we see it, looks like a normal and customary pool. Mr. Ridnour will speak, and Eric, if you want to speak now to what.
It's actually, based on Sylvan, it's actually 64% smaller, or 36% smaller than a normal size pool for that size lot. The proposal that we'd like. Go to what the city proposes, it would be even smaller.
And roughly, you're looking at 7 to 8 foot distance here. This is the back door of the home. And I don't have the ability to scroll back. Well, I probably do, but I don't know how to scroll back to Lisa's slide. But this idea of compliant pool area or compliant building area and utilization of compliant building area. Sure, we can't stand up here and argue against, you can push a pool directly up against the house. And I guess that's compliant building area. But what Mr. Exum's affidavit will tell you is that best practices in the pool industry is for 1 foot of depth, of pool depth, requires being 1 foot away from adjacent structures. Now, we all know the average pool, roughly 6 feet in depth. Diving pools need to be 8 feet in depth. So Eric's already mentioned that in terms of size and square footage of what he is proposing, it is smaller than what is customary. But to put it 1 foot, 6 inches, that close to a structural component of a home violates the best practices in the industry. And he is being advised by Anthony and Sylvan Pools, well, we won't build that because that's not safe. The structural supports for the home, they go 20, 25 feet down, but the envelope around any structure also helps provide its support. So therefore, best practices say you don't dig a 5-foot hole 6 inches from a structural support for a home or any structure for that matter. Go ahead, Eric.
I even asked them if they would, and they said they would not build it. And if I did get somebody to build it, it would breach my warranty for the home.
And again, before I move on, if you if you take this sewer line and extend it into the lot next door that received the 8-foot variance, you will see the angle is running closer and closer to the structure. And it is for that reason, as Ms. Talbom has provided by affidavit, that her request was driven by not what she felt was a reasonable request to make to the board in terms of a variance from the strict application of the setback. It was driven by the location of the sewer line and not being able to get closer than 5 feet. Here is the decision that this board rendered in that case that spells out, the issue. We're here because the front yard is the rear yard. We have these, given the lot configuration, we have these 341-foot setback, in this case, 360 in our case, and just runs through the board's reasoning for allowing accessory structures up to 8 feet into that required setback. And before we sort of look at the city's alternative, I just want to speak to the criteria for the variance request. Unnecessary hardship caused by strict application of the zoning regulation. Well, here, we've got a home that in all respects looks very similar to lots of homes in Charlotte. He's got a front yard, he's got a rear yard. He has a reasonable expectation that he can put a pool in his rear yard. And the only thing that is preventing it is the fact that his backyard is the legal front yard. Normal rear yard requirements in this zoning district would not prohibit what he is proposing. In fact, would allow him to do something larger and what he would ideally like to do. So we feel that the inability to do not only what his neighbor did, but what some other lot owners, which we'll get to, have been able to do, and most every other lot owner in the city, that is an unnecessary hardship that is caused solely by application of the required setback and established setback lines as it relates to this lot. That is driven by the peculiarities of the property that Lisa and I have mentioned, the lot configuration, the front, rear, the creek, the detention pond, all of those issues. This was not created by Mr. Ridenour. Was not created by the builder. A subdivision developer created this lot several years ago. And so that criteria is satisfied. And we would offer that the request here is consistent with the Spears purpose and intent of the setbacks, in that front setbacks, the intention is to not allow you to clutter up the front of your house. This will all be well screened, as the board has acknowledged already. And we feel that the spirit and intent of the zoning ordinance will be protected here. What we're proposing does not create any public safety issues. In fact, what we have proposed versus what the city's alternative is, we're on the right side of the safety discussion, as Mr. Exum's affidavit supports. And common sense, you don't put pools 5 feet from your back door. You have an area of circulation. Lots of common sense reasons that is the safe way to do it. And then the criteria speaks to substantial justice, fairness. His neighbor able to put in a pool, an 8-foot variance. It's only fair and just that Mr. Ridenour would be able to do something similar. Here's the city's alternative. utilizing the compliant building area to avoid the need for the variance. Again, you will see 5 feet from the door. This is actually 3 feet from the structure. That's what it would look like. It brings into clear focus potential safety issues that can come from that. Again, a side angle showing you what it would look like. And next door, it ended up looking something like that. But again, that was driven by the sewer line. That wasn't driven by the setback line. Couple of additional cases here from 2021. Similar lot configuration. This was driving the front setback, and then there are swim buffer requirements. Now, this situation required a variance from the established setback. It did not require a variance from the required setback, but it did require a variance from the established setback. And this, in comparison to what we are proposing, appears to be situated normal and customary distance from the house, not crammed right next to it. And this variance was granted. This is what it looks like compared to what we're proposing. Another recent decision of the board, this was a situation where this lot, public, both of these are public streets, so front and rear. So here, per the ordinance, when the lot abuts 2 public streets, the front setback applies throughout the lot. Rear yard does not apply, so you're dealing with front setbacks. Here, this front setback line was 55 feet. Well, this home was constructed before the zoning regulations were adopted, so it was legal non-conforming use. A couple years ago, they go in to add a pool. Well, they need a variance because setback line is in this area. The board saw fit to allow that pool to be constructed and granted a 25-foot variance. We're asking for less than 8 feet, which was granted to our neighbor. That's the conclusion of my presentation. Mr. Ridenour, anything else you want to add? And we're happy to answer any questions.
I understand the city, wants to use all available space. I feel like I am because I've got to be 6 foot off the house, the footer, to use all available space because I'm digging 6 feet down. Can't get a pool company that will build that right up against the house without breaching my warranty or paying somebody that isn't a reputable pool company. I don't know, this is none of my doing. I'm just a layperson that pays taxes like the rest of you guys. And I can't imagine that anybody would want to have the consequences of this when all I'm asking is for something smaller than a normal size in my backyard, which is technically my front yard because of the way it was zoned.
Board, do you have questions?
So you have a proposal for a pool that's pushed, what's that, 3 feet off of that bedroom, dining room to the left there in that photo?
Our proposal,
No,
City's
the
proposal is
alternative.
3
So
foot.
you're saying that's not feasible?
The pool company won't build it.
Okay.
Unless I have a pool that's 3 foot deep in the ground, which nobody would want, I'll just sell the lot to somebody else or sue the builder.
So, yes, if the standard is there possibly some compliant building area? Yeah, you can put a 1-foot pool, 1 foot deep, sure. But this board has consistently said that's not the standard, that we end up with, that's okay. That's okay.
Yeah, you mentioned circulation space around it, and that is common sense, right? You don't want to squeeze, 2 running kids in 3 feet or 2 feet. So I understand that safety issue. I'm kind of surprised that Mr. Exum didn't have anything in his affidavit indicating kind of the safety aspect of a pool deck and its distance away from a house. I mean, when I look at the neighbor's house, it does look of concern that somebody would come right out of the house and potentially fall into the pool. So I recognize that there is kind of that circulation space, but there's nothing in the information that kind of indicates any facts about or any sworn testimony about the safety feature other than what you're saying, which is the structural integrity of the house and the pool, having that distance away. I guess, is there any information that you could add relative to pool safety on a deck?
Well,
It's distance away from a house or a door?
I would say that Mr. Exum has included the safety aspects of the circulation, just to your point. He does mention what's called the angle of repose is the 1-for-1 ratio, but I think he does speak to the circulation issues. I would just offer to the board that those things are in all of our common knowledge. That doesn't require factual testimony beyond what everybody in this room knows to be the case.
I know when they're building my kitchen and they have an island, they want a certain distance between,
Yeah, you gotta have more room between your island and your cabinets than this.
I have a question, and I don't want to get too hung up on the front yard versus backyard question, because I think they're trade-offs when you are, is that a public road or a private road that goes up through there?
This is private.
Okay, so it's a private road, which is essentially built in the backyard, so that if it were the front yard, the front setback would push you even further back on the lot. So I don't want to get too far into the semantics on all that. But just kind of in looking at just the backyard, would a pool be able to be built in a backyard that close to the setback? If that rear property line,
Yeah, the normal rear yard requirements in this district, like a 3-foot
okay,
from the rear yard
for a pool,
for any accessory.
accessory, right?
There's
got
no
it.
distinction here for
Right.
what we're presenting in terms of a swimming pool. There's nothing unique here about a swimming pool. It's an accessory structure in the setback. Just so happens, of course, if you're going to build a pool, you got to show a pool. And that's the main driver here, but the analysis here is the same for any accessory structure.
Gotcha.
Excuse me. And I would just say that, and yes, we want the board to understand what the board has said in the past. And we consider our situation to be identical to the lot next door, if not less, because we're asking for less. And if you are doing the exercise to look and see, okay, what's the apples to apples sort of comparison? Well, that pool is crammed up against the house. The request is for relief from the setback line. And that is what should drive the comparison as to what is a similar situation, what is an identical situation, and treating one lot owner one way requires that you treat the next lot owner the same way. And then when you have the practical realities of other variance requests, not driven by the exact same issue, but seeking the same practical result, we see what has consistently been okay.
May I ask, the pool size, regardless of the variance you're requesting, the pool size is narrower because of the sewer line issue? I mean, you can't build a full-size pool because of the proximity to a sewer line, correct?
That is correct. What we have proposed is 5 feet from the sewer line, 5 feet 1 inch from the sewer line. The net result being 36% smaller than, and it's actually, and Eric, correct me if I'm wrong, that 36% is driven off of the smallest pool and price point that Sylvan installs. And that is in the 350 square foot range.
And that has been approved by Charlotte Water and Sewer.
That has been, as part of our application, you will see the approval.
Yeah, the 5-foot setback.
Okay.
An average, what Sylvan has told Eric and I is that the average pool is 500 to 550 square feet.
Any other questions? Or
Yeah, can you confirm that that lower level that's going to be, the pool's going to be right outside, that's just a slab on grade, correct?
No.
Right there,
That-
outside of those doors.
That is structural for above.
So the doors
or
and the
inside?
window,
There's the doors, but this is structural for the second floor.
is that what the pool builder is concerned about, those columns and the angle of approach? Because my understanding is it's more about the distance off of
They want,
on
they
long
want the
elevation.
distance from the columns to
Yeah.
be 6 foot and the distance from the footer of the house to be 6 foot.
So, yeah, can you confirm that that is a slab on grade at that lower level? You mentioned
It's
footer.
concrete. You're talking about,
Yeah.
yeah.
So there isn't technically a foundation at that side. I mean, it's a slab on grade. I just wanted to confirm that, and it appears from the photos. When you talk about angle over pros, so really your angle over pros is at the finished floor elevation or the bottom of that footing, but that footing's only going to be 8 inches. It's not that there's a additional basement or that.
Correct. That is the
Yeah.
basement. It's just a slab.
Thanks.
But here, 3 feet from the actual foundation of the home, that goes, to my knowledge, 24. I think it's a pretty deep pilings.
So is that due to soil conditions? I mean, if you talk about angle over pros, so that would be the bottom of those foundations, right? Not the top. That's why the question about structural integrity, if you're saying there's piles, right, that load's being transferred to the bottom of that. I'm curious about this
But it-
kind of
it
argument about the structural integrity.
It works as a system. Like every,
Right.
you don't structurally moor any structure just at the bottom point. It is load bearing all the way down.
Okay, so that slab sits on piles. I mean, it's kind of.
I don't know, when I bought the lot, there were 4 piles, but they were where this covered area is, where the screened-in porch is. That's where they were. I didn't see them on that side of the house.
Okay. Yeah, just trying to work through in my head the structural integrity
Sure.
sort of piece of this.
Sure.
Plays into that argument. So who did that rendering? The pool builder?
Which rendering?
The one that's on the
The-
screen where it shows the pool 3
Sylvan
feet
did
away?
this rendering.
Yes.
Even though they said they wouldn't build the
Well,
pool?
because we were trying to depict what the city was.
Well,
That's
I
not a-
wanted to show you guys what it looks like.
Yeah, I wanted to confirm who
Yeah.
created that diagram.
Yeah, that was created by Sylvan. happy to provide that to staff as needed.
Thank you. That's all the questions I have.
In fact, his affidavit speaks to Sylvan analyzed the city's alternative. This is the visual product of that analysis, and that affidavit is there.
So how deep is the pool that you're requesting?
A normal size depth, 6 foot.
6 foot, okay.
We're not trying to go 8.
Any other questions? All right, thank you very much. All right, we have now concluded the portion of the case that pertains to the presentation of evidence. Oh, you want to, okay. Lisa?
This firm was kind of in the same situation. It's not a clean survey, you can't really.
Yeah, closer to the mic.
The established setback would run something like this. So in this case, there also wasn't room in the established side yard to construct a pool. And I just wanted to, reiterate that variances are site specific. So every property is based on its own facts. And just distinguishing between this request and the neighboring request at 6226. At 6226, there was not compliant space to place a pool. And then also in staff's proposed possible option, that was just one of many options that could certainly be reconsidered.
May I address one thing that was sort of new there? Please correct me if I'm wrong on how you guys, that the established setback would not be this sort of 90, it would be driven by that road, right? So it would be more of an angle. Now, I don't know where exactly it lays here, but the variance was granted because that pool did encroach into the established setback. Correct. No, I understand.
The
Yeah.
established side.
No, I understand. And we don't think you can safely build in this compliant building area. And the logical extension there is you can safely build a pool flush to a home.
Okay, any other questions, comments? We will now move into our deliberations. Interested parties are not permitted to address the board during this portion of today's meeting. However, everyone is permitted to remain present and listen quietly to the board's discussion and vote.
Madam Chair, just for the record, there's no opposition for the
Is there no opposition to this? Okay, thank you. So there is no opposition from neighbors. Mr. Hamid, would you like to start?
Sure. Appreciate your time and appreciate how you're looking at this case. I think it was very informative. It paints the picture and it also kind of shows other examples of what's being done, obviously both directly adjacent to your property or potential home and others throughout the city. And I think the city, in their case for that kind of proposed alternative, is considering the facts of this particular lot and its differences between the adjacent lot and the other precedent examples that you pose here. It's obvious that this lot has unique characteristics about it that are reducing the ability for you to develop it in the way that you'd like to, and of no fault of your own, although it's good that you kind of recognize those before you commit to the pool, and it sounds like potentially to the house. So I commend you on being in front of it, making sure that you're doing your due diligence as you move forward into this home construction and home purchase. I think the information provided gave me enough comfort to make a decision, but I'd like to hear from the rest of the board what their take on it is as well. I appreciate the time.
Thank you. Mr. Court, comments?
So I guess one of the factors that I'm considering is the concept of what could be built or should be built, or the extents of what people want to build, and thinking about the major limiting factor being the sewer line there, and what's fair to specifically the people within this row of properties. And I think I think people may, I think that the peculiarities of the property have definitely placed some hardships on everyone in doing that, everyone consistently throughout. And so there is a limitation on how big these pools can be due to that sewer line. And so it's really not an arbitrary limit. There's an actual limitation to where it is. And so I don't think it, I'm kind of leaning toward approval of the variance. I feel like I'm sympathetic to the argument of pools in proximity to houses. I don't have any direct experience with structural failure in those situations, but it doesn't seem like a good idea to be building that close to a pool that close to a structure.
Thank you very much. All right, Ms. Soon, you have comments?
Yes, I'm leaning towards approving the variance, because the proximity towards the house would potentially cause danger to, for example, little children, small children and kids, and therefore I move to approve.
Mr. Williamson, comments?
Yes, I think that I would think that this would be approved just because they're not disturbing anybody behind them. They're within the setback for the sewer. The fact that there's a buffer behind them is important because it is site specific. Each one of these is unique in its own character. And I think just because there is the ability to be compliant doesn't necessarily make compliant the best idea. Having a pool that close to a screen porch, I can just see a teenager trying to jump off that one day, and I'd rather have that pool further away from the house if it were mine. So, yeah, I would probably make a motion to approve it.
Thank you. I think my concern is like the letter of the law. I mean, just because there's space doesn't mean it's the best option. My concern, I guess, with the smaller pool is exactly what Mr. Williamson just talked about. The depth of that pool can only be 5 feet. I mean, 5 feet is very shallow depth. And so if you have anybody jumping, especially a teenager or a young adult, that pool depth is concerning to me. I appreciate the exhibit of the affidavit from the pool manufacturer and the statement that technically he would not build that pool that close to the house. I agree that it does not infringe on anybody behind them because there's a buffer, that it is impeded because of the sewer line that runs through the property. So with everything that's being considered, I am inclined to approve this request for variance. Any other comments from the board? Do I hear a motion?
Motion to approve?
Do I hear a second?
Amy, second.
All right, we've had a motion to approve and a second. Ms. Soon,
Yes.
Mr. Williamson,
Williamson, yes.
Mr. Hamid,
Hamid, yes.
Mr. Court,
Court, yes.
Dryden, yes. This variance is approved.
Thank you.
All right, now we need to look at the finding of facts because we do need to amend those since we have changed. So I'm looking at number 14. That says the hardship is caused by the applicant. So I think we need to insert the word not there. The hardship is not caused by the applicant.
So, Madam Chair,
Yes.
the applicants have submitted their proposed findings of fact, which would grant the variance. So that, I'd like to point you to that, if you'd like to consider some
Okay.
of those findings of fact or basing.
Is that exhibit
determination-
3?
Yes.
Okay. All right, board, take a moment and look at exhibit 3 that the applicant has submitted.
I guess, can we
Yeah, go.
drop some questions real quick? So what are the implications of changing the applicant? I mean, just out of gates from Eric Ridenhour to Copper Builders.
Well, okay.
I'm sorry, I apologize. I thought these were proposed findings of fact.
Okay, thank you. Okay, I was confused too because I was looking, this is just the exhibit. Okay, so let's go back to the original finding of facts. And so all is well until we get to number 14, the hardship. So we need to insert there not, correct? The hardship is not caused by the applicant.
Can I just clarify something? I did prepare what are proposed findings of fact and conclusions of law, but I did it in the template of the board's previous decision letters. And that's what Exhibit 3 was intended to be. Defer to the board on working through the findings of fact. If that needs to happen here, yeah, certainly.
It does.
That was just one alternative.
I got you. Okay.
Gotcha, thank you.
And I don't know if this matters, but I own the lot currently.
Well, yeah, you really can't interact with us now because we're doing this, but we appreciate that. Okay. Okay, so 14, what about 15?
Sorry. Yeah, it's the builders.
There, it says there is, how do do we just eliminate that altogether?
Well, it is a fact,
Okay,
right? There is compliant building area to construct a pool, but it goes on to say that the variance is needed because of the size and placement of the proposed
okay,
pool.
so then we can
would-
leave that, right. Setback, the established side yard is defined. All right, what about number 19? The hardship does result from conditions peculiar to the property, correct? Because we talked about the sewer line being so close. For number 19? So the hardship, we're taking out the word not.
And that's consistent with what has been presented to us.
Yes,
as
mhm,
Previous decision.
right. What about number 20? There is compliant building area. Well, I guess that's true. And number 21, we need to take out the word not, because the requested variance is consistent with the spirit, purpose, and intent of the zoning ordinance, correct? If we're gonna approve it, we have to take out the word not.
I agree.
All right, the requested variance to encroach is necessary to increase the size of the pool and the distance from the home, that's correct. Okay, since the pool can be built compliant with the zoning ordinance regulations, a variance is not necessary to construct a pool on the property. I think we need to just take that out altogether. Comments, questions? I think, because it doesn't, I mean, we're approving the variance, so it doesn't, we don't need to say it's compliant to be built elsewhere. So 23 is out. 24, that's different, okay. These are all right. Okay, so unnecessary hardships would result, so we need to take out the word not from number 1 under conclusions of law. The hardship does result, take out the word not. The hardship does result from actions taken by, all right, does not. Now, number 3, the hardship does not result in actions taken by the applicant, and the requested variance is consistent. So we've taken out not, we've added not and taken out not to make that compliant. Do I have a motion to approve the finding of facts and conclusions of law as amended?
So I'll make a motion to approve.
Ms. Sun, do I have a second?
Williamson, second.
All right, I have a motion on the floor to approve the finding of facts and conclusions of law as amended. Ms. Sun,
Sun, yes.
Mr. Williamson,
Williamson, yes.
Mr. Hamid,
Hamid, yes.
Mr. Court,
Court, yes.
Dryden, yes. Thank you very much. Yes, that's, thank you. I was getting ready to. All right, the board will take, let's take 10 minutes and reconvene at, let's see, 10:47. Thank you very much. All right, ladies and gentlemen, we will reconvene the meeting. And our next case is see, case number 2023004. And Lisa, you may begin your presentation.
This is an accessory structure variance request. The applicant is requesting a variance to permit a pool within the established setback and 4.1 feet into the 473-foot required setback. I'll give you a minute to look at your findings if you'd like.
Okay, Lisa, you may continue.
Exhibit number 1 is a vicinity map. Exhibit number 2 is a zoning map. It's zoned R3 single family. Exhibit number 3 is an aerial map. Exhibit 4 is a close-up aerial map. Exhibit 5 is background. The property was subdivided in 2020 and the home on the property was built in 2022. The property meets its frontage requirement along Gilchrist Road, but the front of the home is oriented towards the lot's rear yard and private drive, Lewis Patrick Lane, and that provides access to Montclair Avenue. Exhibit number 6 is the variance request. There's a 473-foot setback off Gilchrist Road shown on the recorded plat, and that supersedes the required R3 setback. The established setback is located between the right-of-way of Gilchrist Road and the existing home. There's about a 4-foot distance between the established and required setback. The property is currently compliant with the established and required setback. Per code, accessory structures are not permitted in the established or required setback. So the applicant is requesting a variance to locate a pool within the established setback and 4.1 feet in the required 473-foot setback. Exhibit number 7 is considerations. Staff finds the variance request does not meet all the criteria for granting a variance. The hardship results from actions taken by the applicant since there is compliant area to construct a pool in the established side yard, and that's located behind the established setback to the side of the home. A variance is needed due to the desired size and placement of the proposed pool. If the pool were located in the yellow highlighted area in the right graphic, no variance would be needed. Exhibit number 8 is considerations. The hardship does not result from conditions peculiar to the property. There are some unique features of the property, but there's still compliant area for a pool. The requested variance is not consistent with the spirit and intent of the zoning ordinance. It's necessary to increase the size of the pool and the distance from the home. Again, we have that 6226 Lewis Patrick that was previously approved in 2022, and it was granted an 8-foot encroachment into the required and established setback for a pool, but that request differed. To the left, you can see the previous request had a proposed pool depth of 8 feet, and the pool was placed directly adjacent to the back of the home. The home was built so it's very close to the required setback, and there was not compliant area in the established side yard to construct a pool. To the right is the subject request, and it's a pool located 4 feet from the home and 13 feet in depth. There's compliant area in the established side yard to construct a pool. The rear home elevation submitted with the building permit for the home on the subject property shows the pool directly adjacent to the home. There's about 11 to 8 feet of compliant depth from the home to the established setback line in the compliant building area. And the pool they're proposing is 27 feet in width, and that allows for a 4-foot path. Exhibit number 9 is a photo of the subject property, and that's the end of my presentation if you have any questions.
So can you explain so there's no opposition, is that correct?
No, sir.
Okay. Can you remind me the method of notification of adjacent property owners other than obviously there's that sign there.
They're notified within 300 feet of the subject property. And then there's a sign posted on the property. So a letter goes out to a radius of 300 feet.
Radius of 300 feet. So if you touch it, you're 0 feet? Okay. Okay.
Can you go back to the slide that shows where they want, yeah, that one.
Is there a proposed depth to the pool itself that you're aware of, Ms. McCarter?
Like the depth?
Yeah. Thank you.
And then 300 feet from the front, like every place that property, like 300 feet radius from anywhere that property, like there's a bubble, a 300-foot bubble, not a 300-foot circle.
Use GIS software
Uh-huh.
to have any property that falls within 300 feet of the
Gotcha.
property lines of the property.
Yeah, my concern is that there's a sign on a private road that's a dead end that like only the property owners that own property and all want to build a pool would see. So that's good. That sounds like everybody that may be impacted would, that sounds good. Thanks.
So you're saying that they can build this pool, but there wouldn't be the 4-inch from the covered patio? Is that is that where we are kind of?
Correct. There would still be, it would still allow for the same width, which would allow this 4-foot walkway.
Right. It just couldn't be the depth of. Any other questions?
So according to this alternative proposed pool that you're looking at, Ms. McCarter, so what would the length of it, but what would the width of it be? So you're saying it's from the established setback back to the house, so within that 8 feet?
Approximately 8 feet from the established setback to the home, and then 11 feet on the.
Okay, thanks.
And just want to confirm, the easement has been approved by the utilities.
Yes.
Yeah, okay.
Any other questions? All right, sir, you've already been sworn in, so if you have comments? Okay.
First, thank you to do this. I will try to stick to what is different because these lots are, there's one lot in between them, but it's all the same issue. You have the affidavit from Mr. Exum. I won't belabor that. You have the picture showing from Gilchrist Road. We did prepare, I'm going to put them in the record, similar proposed findings. What I would like to point out is that in the presentation materials, you will see an affidavit from the owner of the lot, Mr. Grumbos, speaking to what he is asking and requesting in terms of the variance. Same, this is 62 22 that we just dealt with. This is 6214. Again, our presentation includes the affidavit from Ms. Talbot, 6226. Same front rear yard issue. There's what it looks like, excuse me, looks like from above. There is one meaningful difference factually. This home is complete, CO'd, and occupied by Mr. Grumbos, or Mr. and Mrs. Grumbos. Another relevant, Lisa mentioned a 473-foot setback. So in terms of practically what we're dealing with, 473 feet from Gilchrist Road, and asking for a small amount of relief. That is the home, again, Lewis Patrick Lane, backyard. Here's what the backyard currently looks like. Another depiction. There shows the coverage, the creek, everything. Affidavit from Mr. Grumbos, making the request and what it's based on, and the advice that he has received from Sylvan Pools in terms of the best practices. There's what it looks like. We are in the 1 to 4 foot range. Here I'll defer to the application, but this is far less of an encroachment than what we just talked about. Again, that is what we are proposing. The Grumbos have received the same encroachment agreement with CMUD in terms of the sewer line. And given the angles that we're talking about, you will see that this is less of a request. Ms. Talbot's affidavit, here's the city's proposal, again, snug to structure. That's what it would look like. That's what it would look like. And those columns there are structural. For the dining room for the home sits there. And that's happy to answer any questions specific to Mr. Grumbo's request. I will say for the record that we do feel it's an unnecessary hardship, the inability to be able to build a normal and customary, albeit smaller, safe pool, given the unusual lot configuration and the flipping of the rear yard and the front yard. Mr. Grumbos, who owns the home, did not create the issue, nor did the applicant, Copper Builders. And the same fairness and justice would apply, as applied to Mr. Ridenour's application. And granting the variance, we feel will be consistent with the scope, purpose, intent of the ordinance. Refer to our application for anything else. I'm happy to take questions.
Any questions?
Yes. It's Marshall Williamson. The previous pool was proposed to be like 5 feet away from the house. This one's 4 feet away. It sounds like he's got another 5 feet before he work with to get to the sewer easement. Is there a desire to have it more than 4 feet away from the house? I'm inclined to give him leeway to go all, as far as CMUD would let him go if he so desired. So I guess my question would be, does he want it 4 feet from the house, or would he rather have it 5 feet from the house there away from the covered patio?
We made our request, but we will accept any additional flexibility that the board deems prudent in terms of granting the variance.
And what's the proposed deep end of the pool?
My understanding is the Grumbos are planning a 6-foot pool.
Well, that's the city's proposed alternative. Where's their proposal?
There.
So they're asking.
Just so I'm following correctly, so the angle of repose is not an issue in this case?
The angle of repose is a definite issue in this case, in that we can't have a pool without violating it significantly. Again, my understanding, I don't know for a fact that the depth is committed to one way or the other, and have not had that conversation with Mr. Grumbos. My understanding is no more than a 6-foot pool here.
So would your diagram not need to indicate that the pool is 6 foot off the face of the covered porch?
Would it not need to indicate that for?
Or the argument in the previous case indicating that the depth of the pool needs to be the same distance or more or less than the distance away from the structure?
Well, to the extent that the board would like to condition that the pool be further away from the house, that makes plenty of sense.
Thank you.
But in this case, the pool company is not saying they will not build it if it's only 4 feet away from the house.
That is my understanding. They have prepared these renderings based on what we proposed and did not go into the linear details in the affidavit. Oh, and I do want to point out, I think we did. This is poolside Lanai, which gives the impression that this is the structural end, but this is structure as well as the dining room sits on top there. So that is structural element of the home.
Any other questions? Thank you, sir. I appreciate it.
Thank you.
Anybody opposed to this?
No, Madam Chair.
Thank you.
And for clarification for member court, there were 50 notifications that were issued regarding this property.
Thank you, sir. I appreciate that. All right. We will now,
Chair, do you want to make sure if staff would like to
rebut
or present anything?
present anything in it? Yes, go.
Rebuttal.
Thank you.
Just say again what I said last time, that the hardship needs to be based on the property and not personal circumstances. Variances are site-specific. Staff finds it doesn't meet the required criteria for granting a hardship since it could be built in compliance. Staff finds that it could be built in compliance, so it doesn't meet the criteria for granting a variance. So that's all.
Thank you, Lisa. All right, we've now concluded the portion of the case that pertains to the presentation of evidence. The board will now proceed to the discussion and decision portion of the cases. Interested parties are not permitted to address the board during this portion of today's meeting. All right, discussion. Mr. Williamson?
I'm in favor of it. I think it's consistent with the rest of the street.
Mr. Court?
I think I'm in the same boat.
Ms. Soon?
I'm in agreement.
Mr. Hamid?
I lean to approve.
Do I hear a motion to approve this variance?
Court move to approve.
Okay. Do I hear a second?
Williamson, second.
All right, we'll go to the roll call vote. Ms. Soon?
Sun, yes.
Mr. Williamson?
Williamson, yes.
Mr. Hamid?
Hamid, yes.
Mr. Court?
Court, yes.
Dryden, yes. This variance is approved. All right, we need to now amend the finding of facts and conditions of law.
And again, I'll just remind the board that the applicant has submitted proposed findings of fact. I think you might need to change the applicant, but those are also available for your consideration,
Okay.
rather than trying to flip-flop staff's findings. Look at those as well.
I mean, I would prefer just to amend what, that's up to you, board. What do you want to do? Accept his defense. Can go through. Because I think we start with number 14, if we look at our finding of facts. The hardship is caused by the applicant, so we would insert the word not there. The hardship is not caused by the applicant. Number 15 is a correct statement. There, okay, other side yard is defined. Okay, there's a compliant. Number 19, the hardship does result from conditions peculiar to the property. We're going to approve it. Number 21, the required variance is consistent with the spirit, so we take out the word not.
Struck number 23
Right,
on the previous.
that's correct. And then we need to, unnecessary hardships would result, so we take out the word not, and take out the word not. And we add the word not for number 3, and then take out the word not.
Is there any magic to 25 findings of fact? They both have 25, both the previous one or both the one that was proposed and this one. Is there a goal to reach 25 on these things?
So number 25 just references staff's position
Okay.
on the variance.
So there's no impact to us
If
approving
you-
only 24 findings versus 25 findings.
Sure, if you adopted, if you kept number 25 in, staff finds the previous request, that's just restating what staff's position is. That doesn't mean that you're adopting that as your finding of fact. If you are adopting it, I would have suggested.
Oh, sorry, I wasn't
Say the request differed because of.
referring to number 25. I just meant like the total number of facts.
No.
Okay.
This
It
was
was renumbered
Okay.
It would,
in final,
end up being
final
20.
copy.
All right, that didn't cause a problem for anybody. Good. Sorry.
Okay. All right, do I hear a motion to approve these finding of facts and conditions of law as amended?
Court move to approve.
Court, second?
Williamson, second.
Okay, Ms. Sun,
Sun, yes.
Mr. Williamson,
Williamson, yes.
Mr. Hamid,
Hamid, yes.
Mr. Court,
Court, yes.
Dryden, yes. The finding of facts and conclusions of law are amended, are approved as amended. All right. All right, next case is number 2023-005.
Right, our next case is a commercial setback and curb line variance. The applicant is requesting a 5-foot variance from the required 20.5-foot future curb line in the center line of a street for a new multifamily development. And I'll give you a minute to look over your findings. The original application did include a setback variance, but the applicant withdrew that portion of it, so.
Say that again?
The original application included a setback variance as well as a curb line variance. The applicant withdrew the setback request.
So we are only now dealing with the
Curb line.
curb line. Okay, thank you. Okay, Lisa, thank you. You may continue.
Exhibit 1 is a vicinity map of the property. Exhibit 2 is a zoning map. The property is zoned TOD UC, which is Transit Oriented Development Urban Center. Exhibit number 3 is an aerial map of the property. Exhibit 4 is a close-up aerial map of the property. The applicant wishes to develop 3 properties along West Boulevard with 1 building, and so that's the outlined area in red. But the variance request specifically applies to this property on the corner of Hawkins and West Boulevard because it involves Hawkins Street. Exhibit number 5 is background. There's currently a 1971 retail building on the property. The applicant proposes to redevelop the property with a multifamily building with ground floor retail. The applicant submitted for land development review and I believe received 1 initial round of comments. Exhibit number 6 is the variance request. The property is a corner property with frontage along Hawkins Street. The code requires a future curb line of 20.5 feet from the center line of Hawkins Street, consistent with the commercial wide street cross-section shown to the right. The applicant is requesting a 5-foot variance from the required 20.5-foot future curb line. You can see the requested curb line to the left and the required curb line. Per code, the required 16-foot setback along Hawkins Street frontage is measured from the future curb line. So reduction in that future curb line allows a reduced setback. So this is the requested curb line, 15.5 feet from center, and the setback. And then with the required 20.5 foot curb line and that increased required setback. Exhibit number 7 is considerations. Staff finds that the variance doesn't meet the criteria for granting a variance. The hardship is a result of actions taken by the applicant because the new building can be built in compliance with the 20.5-foot future curb line. Unnecessary hardships don't result from strict application of the ordinance because the applicant can develop in compliance. The applicant has an option of rezoning the property to a TOD EX, which is TOD Exception District, to reduce the setback. The TOD EX provides a way to modify minimum standards for development, where in exchange for reduced standards, the developer is required to provide public benefits involving sustainability, public amenities, and city improvement, and the complete listing of all the public benefits that they would be eligible to provide is in your findings. The requested variance is not consistent with the spirit and intent of the ordinance. The Charlotte Department of Transportation staff has provided input on the requested variance, stating that they do not support the curb line reduction because it will eliminate existing and future on-street public parking, and it would result in a reduction of existing curb line conditions. Exhibit number 8 is considerations. The hardship does not result from conditions peculiar to the property. The subject property was rezoned to TOD in 2019, along with many other properties, including the property to the south along Hawkins Street, referred to as Design Center 1. So this is the subject property and the Design Center 1. The Design Center 1 received development approval prior to the 2019 rezoning, so their development was subject to the code standards at the time of approval and not to the new TOD requirements. The applicant states that the variance would allow them the same future curb line as the Design Center 1. This is common to have differing standards from neighboring properties, and I'll show some examples in the next slide. So it's not unique to this property. Exhibit number 9 is considerations. And these are examples of differing standards in the TOD districts that were provided by an urban plan reviewer in the Commercial Zoning Division. The first example to the left is a vacant parcel on South Tryon Street that's required a 24-foot setback. This is parcel. They asked for a 16-foot setback like the existing development across the street, but they were told they needed to rezone to TODEX. The second example on the right is on West Tremont. They're proposing a building expansion, and it will trigger streetscape improvements. The future back of curb is about 1.5 feet from the existing back of curb. They asked if they could base their setbacks on the existing curb, so their streetscape will be in line with the abutting properties. But TOD requires setbacks to be measured from the future back of curb, so they'll be required to measure from the future back of curb. Exhibit number 10 is considerations. This example is a development on South Boulevard. There's a required 24-foot setback measured from the future back of curb. So you can see the future back of curb is clouded, and here's the existing back of curb. They asked if they could base their setbacks on the existing back of curb because they questioned whether South Boulevard will ever be expanded. And they were required to follow the TOD regulations and base setbacks and streetscapes on the future back of curb. Exhibit 11 is photos. So that's the existing 1971 retail building. And this is just a view looking at the intersection, West Boulevard and Hawkins Street. And you can see some of the existing on-street parking. And that's the end of my presentation, if you have questions for me.
All right, where's the on-street parking they want to do away with? Is it in the front of the building on West Boulevard, or is it that on Hawkins Street?
It's regarding Hawkins
Okay.
Street.
Thank you. Board, you have questions for staff?
So the cars that are parked on Hawkins Street now in that picture, are they, where would the building come to if we grant the approval to the variance? Is it coming to the back of that curb?
So I believe that this is, according to CDOT, who wasn't able to be here today, and my communications with them, this existing curb line is 20.5 feet from the center line of Hawkins. So that would be the required future back curb. What they're asking for is actually less than that. It's 5 feet less than what's existing.
Any indication of why they don't want to rezone TODEX?
I mean, they're here and can address this. I was told it's a timing issue.
Any other questions for staff? All right, gentlemen, if you will stand and state your name and address, and as you do, you will swear and affirm to tell the truth, the whole truth, and nothing but the truth in this matter at hand?
More folks who
Okay.
testimony as well. Chris Tomlinson with Moore and Van Allen. I swear to tell the truth, the whole truth, and nothing but the truth. 100 North Tryon Street, Suite 4700, Charlotte, North Carolina, 28202.
Keith McVeigh with Moore Van Allen. I swear and attest to tell the whole truth and nothing but the truth. 100 Tryon Street, Charlotte, North Carolina. Suite
I'm sorry,
40.
could you repeat your name again?
Keith McVeigh with Moore.
Thank
Keith McVeigh, sorry.
Jeff Kurtz, Ram Realty Advisors. I swear to tell the whole truth, nothing but the truth. 1480 Environ Way, Chapel Hill, North Carolina.
Thank you.
Kevin Caldwell, 500. I swear to tell the truth, nothing but 500 Clinton.
Quinn Augustine, I swear to tell the whole truth, nothing but the truth, 2100 South Tryon, Charlotte.
Thank you. All right, sir, you may begin your presentation.
Thank you very much. And again, good morning. It's Chris Tomlinson with Moore and Van Allen and representing Design Center Phase 2 LLC, the owner in its variance request. And as Ms. McCarter said, we've simplified our request actually from the application that the variance we were requesting is for the curb line to be located 15 and a half feet from the center of Hawkins Street rather than 20 and a half feet from the center line. And show that this variance is really only needed for approximately 1/3 of the length of the property, because the remaining length of the property, 15 and a half feet from center line is allowed, as you see there. And then this part, because is the garage entry and the alley. And so it is really this part where the variance is needed, which consists of 3 on-street parallel parking spaces. And those is about 86 feet, about a third, a little over a third, because it's 220 total feet of frontage on Hawkins Street. So the variance is really only for a third of the length of this property. And I think these 3 on-street parallel parking spaces are the only arguable benefit to insisting on the 20 and a half feet from the center line here. On the other hand, the variance we are requesting is necessary to provide consistency in the pedestrian realm on this side of Hawkins Street and to ensure that Design Center 1, which exists and was previously developed, aligns with Design Center 2 with the building, the retail on the ground floor, the landscaping, the sidewalk, and the curb line, all of which we seek, the variance we seek would align all of that along Hawkins Street. In addition, so if the variance is not granted, which this is pre-variance, the building Design Center 2 would be set 5 foot back from Design Center 1 building. Also, the sidewalk would jut this way, at least 5 feet, halfway through the block. And the landscaping and amenity zone would also be back 5 feet, so none of that would be aligned. And as I'll show some pictures in a minute, with the variance we are requesting, which is on the right here, the sidewalk would be aligned all the way up and down the block. The buildings would be aligned, the curb would be aligned, and actually the sidewalk would be aligned on the other sides of both West Boulevard to the north and Worthington to the south. So it would be one aligned streetscape and sidewalk. As you also, I want to get some testimony from the engineer in a moment, as you'll hear, the reason that the plans for Design Center 2 were prepared with the 15 and a half foot curb line was because the project development team was told at the pre-submission meeting that the curb line could be modified to be consistent with Design Center 2. And that was specifically addressed at the meeting because that was important to the owner and the designers, because Design Center 2 and Design Center 1, both of which are significant developments, were intended to be in tandem, to be uniform, and to offer a consistent and attractive retail frontage, as well as the rest of the buildings. And that's why that was brought up at the pre-submission meeting. And CDOT said that told the design team that the that the curb line for Design Center 2 along Hawkins Street could be the same as Design Center 1. And that's why the building was designed to be where it is in what we're asking for a variance at this point. Also, one other effect of if the proposed variance is not granted is on the other side of Design Center 2, you see this open space and green space, which is required to be 9.5 feet wide. And if the variance is not granted, that would be squeezed there to 5.5 feet, and the project would have to be redesigned to find that additional open space somewhere else on the project. And this part is actually the main entrance to the housing and the main entrance to the building on this side of the street. On this side of the street, we're asking for the variance. is going to be retail frontage, which is the same as the retail frontage, which is retail frontage down here on Design Center 1. It's actually the Salted Melon Eatery, if any of you have ever been there. So I want to address the hardship considerations briefly. The unnecessary hardship would result from the strict application of the ordinance. In addition to having to redesign the project if the variance is not granted, the unnecessary hardship would include an irregular and inconsistent streetscape, curb line, and pedestrian zone along this portion of Hawkins Street. The Design Center 2 building would also have to be pushed back 5 feet, meaning that would be recessed 5 feet from the Design Center 1 building. And that would also squeeze the open space on the right side of the property as well. The hardship results from conditions that are peculiar to the property. This hardship is peculiar to this property because the second phase and only remaining phase of development on this block of Hawkins Street. And the plans for the Design Center 1 project were approved prior to the changes in the TOD ordinance, and the building was completed prior to the submittal of the Design Center 2 plans. And so the fact that Design Center 1 sits adjacent to the property and has been completed is peculiar to this property, and particularly because we're not talking about even any streets that interrupt it, but this is one continuous block of Hawkins Street, and the Design Center would cover this city block. And so that the conditions are peculiar to this property, Design Center 2. The hardship did not result from actions taken by the applicant or the property owner. Again, the hardship is a result of unforeseen changes to TOD regulations in between the development of Design Center 1 and Design Center 2. Is also a result of a reliance upon the representations that were made to the development team at the pre-submittal meeting. They were advised that the curb line used for phase 1 could also be used for phase 2. Finally, the requested variance is consistent with the spirit, purpose, and intent of the zoning ordinance, such that public safety is secured and substantial justice is achieved. Given the representations at the pre-submittal meeting that petitioner's development team relied upon, substantial justice would be achieved by permitting variance. The consistent and uniform curb line, streetscape, sidewalk, building placement, including the retail frontage along Hawkins Street, is consistent with the spirit and purpose of the zoning regulations. And I think sacrificing the consistency and impairing the pedestrian experience is at odds with the spirit and purpose of the zoning regulations. And particularly want to point the board to section 15.1.1 of the ordinance, which lists the goals of the transit-oriented development districts. And the first 2 goals are these. A, quote, support the public investment in transit infrastructure by creating a dense pedestrian scale built environment and a range of uses that encourages walking, cycling, and transit use and lessens the reliance on individual vehicles. And B, quote, develop a high quality, attractive public realm that supports a range of mobility choices by providing wide, accessible sidewalks with street areas and lighting, pedestrian amenities, bicycle facilities, public art, parks, plazas, and open space, close quote. So the proposed variance advances these goals. I think what doesn't advance these goals is sacrificing all of that for these 3 parallel recessed parking spaces. But even if parking is a concern, I do want to point out that Design Center 2 will have a garage, and the garage will include 41 public parking spaces. So there will be parking spaces right here in the garage. Just to show a couple pictures here. So this is on Hawkins Street looking south towards Worthington. So this is kind of the alley that was shown there. This is Design Center 1 and the frontage. This is Salted Melon entrance to the parking garage. And this is where the Design Center 2 parcel that we're talking about starts. And this is the streetscape that's currently in Design Center 1. So what we're requesting is for this to continue on, to be consistent. The trees will line up, the curb will line up, the frontage will line up, so it doesn't jut out all of that. And is recessed. I also have to point out that the variance, I think, promotes safety concerns here. As you can see, currently, there are cars parked along Hawkins Street, where this is 15.5 feet from the center line. If there are, along this entire block, if there's 3 recessed parking places, that creates a safety issue because if those are recessed when there's other parking along the street, there'll be a blind spot. Pulling out is a hazard, as well as cars driving along north on Hawkins Street would not be able to see cars that are parked there as well. So I think that promotes safety. Here is looking the other way on Hawkins, looking north. So again, the variance we are proposing will continue the streetscape consistent all the way up the block. If the variance is not granted, then everything would be basically pushed out this way. These are the adjacent blocks on Hawkins Street. On the left is looking north, close to north, across West Boulevard. And you can see the streetscape there. Again, there's no recessed parking spots there. And then on the right is south across Worthington. Again, the sidewalk continues. So basically, if we look at here, we're proposing is a sidewalk would not only be continue here, consistent, but here. So it would be a consistent pedestrian path for several blocks, really on this whole stretch of Hawkins Street. So would like briefly to ask our engineer, Mr. Caldwell, want to ask you a few questions, please. Can you tell the board your name, please?
My name's Kevin Caldwell
And where are you employed, Mr. Caldwell?
at Geoscience Group, Clanton Road.
What's your position there?
I'm the president of the company. We do geotechnical work, environmental, civil engineering, which is what I do at the company, and construction materials testing.
And what is your involvement with the Design Center 2 project?
We're the civil engineer and landscape architects of record.
Were you involved with the Design Center 1 project as well?
Yes, sir.
Were these 2 projects planned to be coordinated?
They were planned to be coordinated. In fact, on the Design Center 1, we had to take some open space, required open space out of Design Center 2, so they were always meant to be built in concert.
Are the materials and aesthetic planned to be the same?
Yes, sir.
And I guess what's Design Center 1? What's the main building there?
It's the Lowe's. I think they do their IT work there.
And how many floors is that building?
That I don't remember. It's like 40 stories, maybe.
I guess, Jeff, you know how many floors? And can you give us a brief timeline of these 2 projects?
We started Design Center 1 in 2018, sort of getting off the ground. Most of the work was done in 2019. The approved plan preparation and approvals.
And when were the plans for Design Center 2 prepared?
We had a pre-submittal meeting on Design Center 2 on December 21 of 21.
And where was that meeting?
It was a virtual meeting.
And you in attendance?
I was.
Who else do you remember that was in attendance?
The architectural group was representative, ownership was Kevin Parker with CDOT, Kirsty Sanchez and Max Oliver from zoning, Craig Robinson, urban forestry, and Brendan Smith from engineering.
And do you recall any discussion at the pre-submission meeting regarding the location of the curb line for Design Center 2 project?
Yes, sir, we did. We had that same conversation on Design Center 1, and as you described earlier, the CDOT wanted it to line up with Hawkins south of Worthington. And so we continued that. We had the same discussion on Design Center 2. They said, yeah, just keep going to West Boulevard with the 15.5 from center line dimension to back curb.
And who was that discussion with from CDOT?
That was Kevin Parker.
And how did those representations affect the plans for Design Center 2 project?
Well, as you said earlier, that set the back of curb sets the setback, so all our plans are based on that discussion at the pre-sub.
All right, and just want to, just briefly, do you recognize this as an accurate plan for the proposed variance?
Yes, sir.
You recognize this as an accurate depiction of what the pre-variance requirements would be?
I do.
You recognize these as accurate pictures of the current Design Center 1 on Hawkins Street?
Yes, sir.
Recognize this picture as well as the same?
I do.
You recognize these as accurate pictures of the adjacent blocks on Hawkins Street? Yes, yeah, the Worthington on the right and West Boulevard on the left?
Yeah.
Thank you, Mr. Caldwell, and I'll, I think the board can ask you any questions, but I just want, I guess, to conclude before you have any questions that, again, we're not asking for, a variance in the actual setback. The 8-foot amenity zone will remain the same. The 8-foot sidewalk will be the same. What we're asking for is a variance of the back of curb line from 15.5 feet from Hawkins Street to the back of curb, or to that from 20.5 feet for this area. And again, this is not an unusually narrow back of curb setback, because that's exactly what it is up here at the corner, what it would be down here, and what it is along the rest of Hawkins Street. The purpose is not to make the street wider, frankly, it is to accommodate these parking spots, and think that the sacrifice and the hardships that would cause is not consistent with the spirits of these TOD ordinances, and that the variance actually would support the TOD ordinances and what this area is intended to do. I think I'd also just say, as a practical matter, the other side of the street has the same requirements, and as the 3 adjacent blocks on Hawkins Street, again, none of them have any parallel parking spots. And so I think, again, as far as safety, as far as what it makes sense to, as far as this side of the street, to have those, I think does not make sense. But if on the other side of the street, which has not been developed, if there were parking spots there, that may make more sense. But here, we think that the hardships do not justify having to have the setbacks, and that having this Design Center 1, Design Center 2, which are significant developments, to be aligned, to have the pedestrian realm aligned, is warranted, and that's why we request the proposed variance. One more thing to answer, I think, Mr. Hamid's question about TODX rezoning. So that, our understanding is that we could not even be heard on that until the fall of 2023. This, I think the plan is to break ground, Jeff, in April. So that would greatly delay the project.
I have a question about the garage entry, the parking in the garage. Is it paid parking or is it free parking?
Defer to you on that, Jeff.
Validated parking, okay. And that would allow access to those street vendors or street entrances near where those 3 parking places that we're taking away are?
We're intended to be an amenity for the retail that we're providing along both Hawkins and South, I'm sorry, and West. So they are intended to be validated for their use.
Okay.
And there's also a parking garage located here in Design Center 1. And how many public parking spots are there?
A couple hundred, actually.
Where is that parking?
That is right here.
Oh, here, okay,
Yep.
thank you.
Okay, so entrance is right here. To the garage. Right here. Okay, yeah. So this is the entrance to this parking garage. That's a couple hundred public spaces. And then Design Center 2, again, this would be the entrance. And it would have, right now, planned 41 public spaces.
Yep, but now that, the parking spaces for Design Center 1, that parking area does not have access, though, to Hawkins Street, correct? You have to come back out to Worthington. I mean, I'm talking pedestrian, once you park. You can't get back to Hawkins Street from there. Can you?
You can access through the alley.
Through an alley,
Yeah,
okay.
through that alley.
Maybe we can show the pictures here. Oh, I'm sorry. Okay.
Oh, okay. All right, thank
And
you.
sorry, just to add one other thing, we're actually looking at valet parking service that would be offered. As Mr. Thomason had pointed out, that's our main entrance to the residential piece through here. Through there, so that there would be an option for any of the retail guests to also to park in either one of those garages through the valet parking.
Okay. Thank you.
I'm curious about the interaction with CDOT on this and the on-street parking that's currently on Hawkins Street. I've used this street at rush hour a fair bit, not since the Salton Melon went in, but the on-street parking in that area and on the other side of the street is pretty awkward, and it just doesn't feel like it's really all that well functioning right now. Are they going to maintain on-street parking even after they make the street less wide? Do you know?
Well, and again, I mean, this part of the street will not be less wide, this part of the block, right?
Correct.
And so we're not aware of any plans to eliminate this on-street parking.
Okay, and you don't know whether they're going to continue that on-street parking onto the Design Center 2 portion of Hawkins Street or not?
I mean, our understanding that is if the variance is granted, that it would be the same as here, same as this portion of the block. That's why I think that point four, that to have this and then just 3 reset parallel parking spaces, doesn't seem to be a lot of advantage in that, and could actually create some safety issues.
Yeah, I agree. Just from knowing Hawkins Street and the increased traffic that it's getting, it feels like Hawkins Street right now it's like, doesn't even have a double yellow line, like there's on-street parking on one side, and then I would not be surprised if there was enough traffic on that street that they just got rid of on-street parking altogether. But I don't know that that's necessarily helps me answer too many questions about this. You were talking a little bit about your preconceived notions on how you're going to be able to use the property in preliminary meetings and things like that. I know that the plans for Design Center are 20, 30 years old. I mean, what changed, and when did it change? And is that the hardship that you're describing?
Yes, that is one of them. And so what changed is that the TOD ordinance was amended in April 2019. And so that was after Design Center 1 all the plans have been approved and the curb been set. And, the plans for Design Center 2 were well on the way, but, the amendment happened before the plans were approved and, ground was broken. And so I think that change, and the adoption of the new TOD ordinance is part of the hardship and part of the, kind of peculiar nature here, in fact. Because the idea all along, which I think is well supported, is that, it's a uniform streetscape, uniform buildings, uniform sidewalk, uniform curb line, which I think makes a lot of sense, particularly for this block when you're talking about, we're not talking about a kind of just small little retail place, but larger or urban buildings, and retail spaces. I think, as part of the on-street parking, I think that's why, even if they did away with it, that's why it's important that there are public spaces in both garages, Design Center 1 and Design Center 2.
How much retail are y'all proposing to have on the first floor of 2?
Jeff,
Total of 15,000 square feet.
So, and I think if I'm correct, but I think it is all of these would be 3 different retail places, here. And then would there be retail on West as well?
The 2 spaces on Hawkins total about 3,500 square feet. The remainder of it would be on West.
Any other questions?
Yeah, just a couple questions. I appreciate you responding about the TODEX, recognizing that time is money, especially in the developers world. So I can appreciate that and be sensitive to it. This reminds me a lot of really dangerous places in Charlotte in terms of what the pre-variance is proposing. So the proposed variance definitely seems in line with good design practices. Question being, Mr. Thompson, I believe you mentioned a pre-submittal with CDOT, and them acknowledging that kind of aligning the curb and aligning the facade of the buildings, that they were in agreement with that. Do you have meeting minutes to back that up? Is there any documentation indicating that other than your testimony?
Yes, sir. I take lots of notes. So yeah, I got the meeting minutes. Yes, sir.
Okay. That's all the questions I had. Thank you.
Any other questions? Thank you for your presentation. You have rebuttal.
Just wanted to say that it's a new building. It can be built with the required future curb line. If they do want to reduce their requirements, it's very common. The commercial planning team sees it all the time where people want to reduce their requirements. And that's why there's the TODEX option provision in the ordinance, where in exchange for them reducing their requirements, the city gets a benefit. So that would be the recommended choice, since the variance should be a last resort. And also that the variance would reduce the existing curb line condition.
Okay, thank you. Any other questions or comments from the staff or participants? All right, thank you very much. All right, we will now go into is there anybody speak in opposition?
No, ma'am.
Remember this time.
I might ask a question real quick. The approval of a variance that could be granted by a rezoning, is that how common is that we have that type of request?
Common in the TOD districts to rezone to TODE to get those reductions, because they do allow you to get like the reduced setbacks and things you want.
But those are commonly come as a request for variance, as opposed to rezoning, or it's pretty uncommon that they would come to us as a...
It's uncommon that they would come to us for a variance, since there is the rezoning option. So usually, you exhaust other options before you come for the variance request, so they've not exhausted the option of TODEX.
Right, yeah, my worry is that if this is maybe the first time or second time, that this may be an avenue that people seek.
And the city doesn't get the TODEX, which provides the public.
I mean, here, the reason this is unusual is because of, Design Center 2 being the second phase of this project along this block, and that the representations at the pre-submission meeting. And so I think that, that affects the timing of the TODX, a rezoning. And one of the reasons that I think that it's an unusual case here, because if they had been notified at the pre-submittal meeting that this variance was not going to be allowed, then that could have been an option and could have gotten that zoning variance, frankly, without delaying the project. But because of the reliance upon what was said at the pre-submittal meeting, and not finding out until much later that CDOT had, I guess, changed their mind, and Mr. Parker had left CDOT, is why, kind of what necessitates the timing and why it would cause a delay in the project. And so I think that this wouldn't really set a precedent of this being the preferred option, but it's because of that pre-submittal meeting and the timing of everything and kind of the changing of course that has led us to have to seek the variance in order to avoid material delay in the project.
The only other thing I would add to the other differences was the change in the code between Design Center 1, which was built under the prior TOD ordinance, which gave CDOT and planning ability to modify curb at the staff level. When the new TOD regulations went into effect and the pre-submittal meeting was held, the new TOD regulations were very new, so people weren't familiar. And I think there was the discussion was held about the curb line. They felt they could do the same thing they did for Design Center 1 in terms of the curb. But once they dug into the new ordinance further, they realized they didn't have the same authority. The staff didn't have the same authority for the new regulations they did under the prior. But then the team at that point had gone a long way down the road to design. So to Chris's point, that's the difference here, is that timing of the first phase approval, the timing of the new regulations, and the second phase created this unusual circumstance.
Lisa? Just quickly like to say that you base the hardship off the criteria in the zoning ordinance, that unnecessary hardships result from strict application of the ordinance, results from conditions peculiar to the property, in the spirit of the ordinance, not result of action taken by the property owner. There is a provision in the ordinance that would allow this in compliance with the ordinance. And it could be designed so that it complies with the future curb line. So it can't meet the criteria.
Okay, thank you. Any other questions?
So it's CDOT wants to keep the parking spaces?
That's our understanding, that now CDOT wants to keep the parking spaces.
And
I said, we say keep, but actually to have them, because what we're talking about is a new curb line. That's going to be necessitated by this.
So the intent of the zoning classification, one or the other, is kind of decoupled from the actual parking spaces. So I don't know that the TOD is one of the intents of the TOD zoning that they have on-street parking, or, I mean, so from I mean, I know that there are benefits to on-street parking. There's convenience. There's, sometimes it's to buffer for pedestrians from fast-moving traffic and things like that. I mean, sometimes it improves the pedestrian condition. I mean, Yeah, and I can go into deliberations and talk about it more.
Thank you. Any other questions or comments? All right, thank you for your presentation. All right, now we will move into deliberations. Interested parties are not permitted to address the board during this portion of today's meeting. However, everyone is permitted to remain present and listen quietly to the board's discussion and vote. All right. I'm going to start this time. I'm listening to all this about regulations changing and basically the parking spaces aren't going away. They're just going to be more, instead of intrusive, they're going to be there because there's already on-street parking on that side of the street. And in closer to the boulevard, there's parking, and I see, except for the entrance to the alley, there's parking there. I'm concerned about the way that our boards in CDOT, that people say things that maybe they're not, they don't have sufficient knowledge to say them, but they say them out loud, and we lead people down a path that says, okay, we're going to approve this. And then somebody else comes on board and they go, oh, no, that person, it's like the commercial or your when you have your AT&T or your whatever cable company you have. If you have a problem, the person that comes out says, oh, the last guy did it all wrong, so I'm going to redo it. And then the next time you have a problem, they say, oh, no, the last guy did it all wrong, we're going to improve it. And that concerns me with this particular issue, especially since there was an understanding with Design Center 1 that the curb would match. And I like the idea of the curb matching, that as a pedestrian, if I'm going to walk, then I would like to know that the street is straight and clear. So those are my feelings about this requirement, and they're asking for 5 feet. It's not into the middle of the street. There are no, as you said, no yellow markings. There's no parking spaces marked. It's just however you get there and you can park. So those are my feelings as we move forward. Ms. Sun, do you have comments?
Yeah, I would like to say I'm inclined to agree with Lisa that this is taking away on-street parking, and that this could have moved in accordance to the developer's plan, but through a rezoning. It would cost more, but the city would get more benefit in exchange.
Okay, thank you. Mr. Hamid?
I'll try to look at this from a couple different angles, but I think at the end of the day, there's a public benefit of the rezoning process, and then there's the impact to development in Charlotte. So those are the things I'm kind of bouncing around. For me, it kind of comes down to conclusion of law number 4, spirit, purpose, intent of zoning ordinance, and it specifically addresses public safety. And I do think both the parking condition or the as-built parking condition, if it's built per CDOT requirement, is not in the best interest of the public. And I also look at it from a perspective of the more kind of blind spots you have up along a street, the more opportunity for, I don't want to say people to hide, but more opportunity for areas that are less than inviting and maybe less well lit, and kind of dark areas that potentially could be against the spirit of zoning ordinances and public safety. So that's where I stand in relation to the testimony and the facts that have been presented. And thanks for your time.
Okay, Mr. Williamson?
I think the having the curb be consistent with Design Center 1 looks like it would be consistent with what's south and north on Hawkins. I think the reality will be that if we give them that 5 feet of space, you're still going to have on-street parking. There's a substantial development across Hawkins that will be coming up for rezoning at some point in the next few years. I'm sure the city will take a pound of flesh from those people, get plenty of on-street parking when they're asked to do so. I wouldn't see that keeping the consistency with Design Center 1 is going to take away anything from this little strip. We're talking about 3 parking places. There probably going to be 5 cars parked there. If we keep it consistent, people will make do with the amount of space that's there. I think being pedestrian friendly is in contradiction to South End as an overall definition right now. If you can walk around in South End and not get run over by a scooter, I think you're probably safer in the street and not getting run over by a car. So I would be inclined to approve it.
Thank you, Mr. Williamson. Mr. Court?
I'm inclined to approve as well. I think one of the things I'd like to do is try to craft something in the findings of fact about the peculiarity of the property. And perhaps that's something about the fact that this was developed under a prior understanding of the ordinances. I don't know if that is considered a peculiarity of a property or not.
So some of the discussion, I guess, when you're talking about peculiarity of the property, you have to remember it's separate from the circumstances of the property owner or the applicant. You're looking at the property because the variance runs with the land. So if this building is destroyed by a hurricane or someone else buys the property, that variance is going to continue throughout. So that's why it's important to look at the property itself, not the applicant, not the personal circumstances of the property owner.
So I guess that,
In relation to the hardship and those kinds of things.
so that could be more applicable to a hardship, the development system or the development timeline. Could the development timeline and the preconceived design of the property and the change and the fact that it's changed be applicable to an unnecessary hardship or a hardship resulting by actions not taken by the owner?
So there can be consideration as it has been recognized that a hardship may exist where, for example, a building permit was erroneously granted to an applicant, they build something, but the case law also says that that doesn't necessarily prohibit the city from enforcing its own zoning regulations. So even if a mistake was made on the city's behalf, the city's not stopped from enforcing that. But it can be considered, the courts recognize there is some hardship that exists when that happens, but there's also other considerations.
Right. So, I mean, I think that space on the sidewalk is a consideration in pedestrian safety. But I think that where Charlotte's really falling short on their considerations for walkability is in the quality of design of that pedestrian space. And I think that this continuing pattern of changing regulations has created disjointed pedestrian streetscapes throughout the city that work against our, the the walkability of the street. I mean, a big portion of walkability is people wanting to walk. And if the quality of the design in that space isn't conducive to people wanting to walk, they're not going to walk as much. So I think that the design here that is a important factor in the intent of the ordinance.
Any other discussion, board? All right, do I have a motion to approve the variance, or do I have a motion to uphold the staff findings that the variance request does not meet the criteria?
Some motion to uphold staff finding.
Soon makes a motion to uphold.
So Madam Chair, just for clarity, that would essentially be a motion to deny the variance.
Yes, a motion to, yeah,
Just another.
uphold by denying, yes. Okay, do I have a second for that? Hearing no second, do I have another motion?
Court moved to approve the variance.
I have a second.
Williamson, second.
All right, we have a second motion on the floor, one to approve the variance. Mr. Hamid,
Hamid, yes.
you vote to approve, okay. Mr. Court,
Court, yes.
Mr. Williamson,
Williamson, yes.
Ms. Soon,
So no.
Dryden, yes to approve. So the variance is approved. With that, we must now amend our finding of facts. Number 11 needs to read the hardship does not result from actions taken by the applicant.
I agree.
The new building builds in compliance with required 20. All right, what about number 12? The new building can be built in compliance with the required 20-foot. I guess that's a true fact.
That's fine.
Unnecessary hardships would not result in the strict, so would result. So we're going to take out the word not from number 13.
Agreed.
That's true. It's true. All right, number 19, the hardship does result. Take out the word not. Okay, that's good. The design center states the variances. Number 23, the requested variance is consistent with, check out the word not.
Agree.
And then, okay, unnecessary, we're in conclusions of law, unnecessary hardships would result, so take out the word not. The hardship does result. The hardship does not result in number 3. And the requested variance is not considered. Okay. All right, do I have a motion to approve the finding of facts and conclusions of law as amended?
Court move to approve as amended.
Okay, do I have a second?
Williamson, second.
Okay, all right, we have a motion and a second. Ms. Sun,
Sun, yes.
Mr. Williamson,
Williamson, yes.
Mr. Hamid,
Hamid, yes.
Mr. Court.
Court, yes.
Thank you. All right, thank you all. That concludes our recommended agenda and our agenda items for today. Thank you very much. Board, we have a couple of other pieces of business. We must approve the minutes from the December meeting, and those you were sent, or there's also a copy at your table. Uh, all right, do I hear a motion to approve the minutes?
So motion to approve.
Okay, Ms. Zun, any, second?
Hamid, second.
Ms. Zun,
Sun, yes.
Mr. Williamson,
Williamson, yes.
Mr. Hamid,
Hamid, yes.
Mr. Court.
Court, yes.
Dryden, yes. So the minutes for the December meeting are approved. All right, now one other piece of business we must attend to is the election of new chair and co-chair. So do I hear any nominations or any discussion?
Mr. Clerk, did we get any nominations at the last meeting? I can't remember.
Yes, nominations for Douglas to remain chair and Ms. Deborah to remain as co-chair from last meeting. I have not received any other since.
Are there any other nominations? All right, the nomination has been for Mr. Douglas to remain as chair and for me, Deborah Dryden, to remain as co-chair.
Make a motion to approve?
Okay, do I hear a second?
Second?
Mr. Hamid,
Hamid, yes.
Mr. Court,
Court, yes.
Mr. Williamson,
Williamson, yes.
Ms. Soon,
Sun, yes.
Dryden, yes. Thank you. This meeting is now adjourned.